Hello, everyone. Welcome to the J&J Consulting Services call today. Today is December 3rd, 2025. It is approximately 10 a.m. Pacific time. I just wanted to give everybody an update as to what is going on in the case. I know there's been a lot of questions. For those who don't know, my name is Jeff Winkler. I am the court-appointed receiver for J&J Consulting Services and look forward to giving you guys an update today. First thing, the disclaimer that nothing in this call should be construed to be considered legal or accounting advice. If you have specific legal or accounting questions, we do recommend that you reach out to competent counsel on those issues. The first thing I'd like to do today is give everyone a claims update as to where we are with claims. As most of you are aware, or all of you should be aware, that the claims deadline was December 1st. So that was this Monday at midnight. Up to that point, we did receive a total of 963 unique claims, totaling approximately $255 million in total. Keeping in mind, of course, that those are not the claims have not all been audited, and that the dollar amounts are subject to change based on that audit and what the court ultimately approves. So we do expect that those not to be the final numbers, but that they should end up around there somewhere. If you did not file a claim and you believe you should have a claim, I would still recommend that people file claims, although it is past the deadline and it will ultimately be up to the court as to whether a late claim would be allowed or not. But if you do think that you are owed a claim, then I would recommend that you get one on file, knowing, of course, that it's going to be up to the court as to whether or not that will be accepted. So I'm going to go through a group of questions now that we received from investors and try to answer them the best that we can. And if you have specific questions after the call, I do recommend that you reach out to us via email or telephone. Both of that information will relay to you at the end of the call. The first question was, when is our next meeting? So we do try to host a quarterly meeting. So that would mean that the next meeting would be approximately in March of this next year, and so we will get that scheduled once we have gotten through some of the different pieces and determine what date might be best for that. The next question has to do with timeframes, and we'll kind of get into that, dealing first with the question about distributions. And the first question is, will any distributions be paid this year before December 31st, 2025? And the answer is no, there will not be a distribution in 2025, nor did we expect that there would be a distribution in 2025. The claims deadline did just expire. We are in the process of auditing claims and anticipate that that will take somewhere between 30 and 60 days to complete. Once that process is complete and we've worked with all the investors there, we will file a motion with the court and ask the court to approve our recommendations on claims or to make certain rulings on certain claims. And we hope to have that done in the first quarter of next year. And then the question is, well, when will then the distribution happen? So usually once the court has approved the claims process, we will also submit a distribution process for the court to approve, and would typically try to do distribution right after that. The only thing I think that could potentially hold that up would be that if we are expecting a large payment from the Wells Fargo settlement, which we'll talk about shortly. If that payment looks like it's going to come in the time frame or near the time frame of when we would do distribution, we may hold off, 30 to 60 days in order to allow us to include that money as part of that first distribution. But we have to wait and see how that timing works out with the Wells Fargo case, which again we'll talk about here shortly. So the first payment, we do hope that the first payment can go out in the first quarter, but again, due to timing of the additional settlements that are going to happen in this case, it may be pushed slightly depending on that. But if it does look like it would be too long, then we would do a first distribution and then just do a second distribution again when it made sense and we got those secondary funds. Next question is, can you assure us that all investors are being treated equally? Under the claims process, the court has set forth the way in which claims will be audited and how claims will be allowed on the money in, money out basis. And that means that all claimants will be treated equally from that perspective. The next thing having to do with distribution, although the distribution plan has not yet been submitted, once it does get submitted, it will treat all investors the same unless there is some outlier that we are not yet aware of. But in almost every instance, all investors will be treated the same for distribution purposes. Um, has there been a determination of the amount of investor funds recovered for each claim? And if yes, will that info be emailed to each investor? So we will, work with the claimants to make sure that the amount of their investment is known and that it matches with our records, and we'll work with them to help work through any issues that may exist prior to filing the claims recommendation to the court. Then once that happens, then the court will either approve our recommendation or alter our recommendation, and that will ultimately be the decision. As far as the percentage of payout from each of these payouts, we don't yet know that number because we don't yet know the number that the court will ultimately approve for the allowance of claims. And the percentage of payout is obviously based on that total amount of allowance of claims. As we get that information, we will, of course, continue to update that and make sure that people are aware of it. Like I said, there's going to be distributions from the cash that we're currently holding. There'll be distributions from settlements that we are entering into with certain parties. There will be clawback settlements that will occur as far as in addition to some additional litigation that will occur. And so there will be multiple opportunities to gather funds in order to do an ultimate payout. And of course, the last piece of that is continuing to collect assets from defendants in order to pay back what we believe they owe into the receivership. How will recovered funds be distributed? Typically, we do our distributions via check, and we will send those out to the parties. Again, we have not made a final determination as to whether or not that will be the method, but that is typically the method as it is the easiest to do so. And then I think that that once that's been decided, then of course, and the distribution plan has been approved by the court, then we can do distributions very, very quickly thereafter. The next question is, with whatever amount of the payback occurs, will there be a payment plan? Again, so when I'm not sure if that's a question in regards to distribution or if that has to do with clawbacks. But if it has to do with distribution, again, we will do that based on what the court allows us to do. And then if that has to do with repayment of clawback funds, then we can work with you on that to come up with a solution there. The next question is how much do you need to collect to make a second distribution? Typically we just want to make sure that the distribution makes sense. So there's enough funds there to justify the cost of doing a distribution. Although the cost is low, we would want to make sure that there is adequate funds to make a substantial enough distribution to where we're not mailing people $5 checks. But other than that, there is no hard fast rule as to what that percentage has to be. We just do it like I said, when it makes the most sense. Next question has to do with defendants and parties. Is there remaining assets held by the defendants that is retrievable in order to offset some of the funds that they owe? And the answer is yes. And we are actually in the process of working with defendants to collect additional funds from them. Much like we did this, the forensic accounting and this claims process to determine exactly how much investors are owed. We are also using that information to determine exactly how much the defendants owe to the estate as well. And so we, now that we have that information, we've been working with them to help them understand what they owe, and now in the process of collecting additional assets, and we'll begin liquidating those soon. Litigation, third parties. The first question asks for an update regarding Wells Fargo Bank. We have mediated with Wells Fargo Bank now a total of 3 times. In the last mediation, we did sign or agree to a proposed settlement with Wells Fargo Bank, the terms of which are not yet public, but will be shortly. The parties, the attorneys on both sides are working on the agreement, on the terms of the agreement and the documentation. And once that is ready to go, then we will release that information to the parties, well in anticipation of asking the court to hear it. So that will be filed with both the court where the litigation is occurring, as well as the receivership court. And so parties will have an opportunity to be heard on that settlement. If they have specific questions or have anything to do with the dollar amount or who's included or any of that information, that will become available at that time. I wish I could release the information now, but unfortunately, due to the nature of mediation, that information is not public until it's been filed in court. But we, as I said, we will make that information public to everybody, so everybody will be aware of what that potential settlement is and what that looks like going forward. The question is, how long do we think that'll take? Our hope is that we can get something filed here in the next couple of weeks. And so that'll go in front of the court, and then the court can ultimately, both courts then will ultimately decide whether or not to accept that settlement. And if the court does accept the settlement, then our hope is to be able to distribute that as along with the first distribution of payments or funds to investors. So we're excited that there is a potential settlement there and that could bring substantial return to the victims in this case. Additional asset questions. What recoverable assets are still outstanding, such as the Wells Fargo litigation? So there, in addition to Wells Fargo, we are looking at potential litigation against other financial institutions, as well as other professionals, including attorneys and accountants. In addition, we do think that there might be, we do believe that there are some investors where clawback actions would make sense, and we will seek to have people return profits that were made in this case due to the fact that there were not actually any legitimate profit, in addition to clawing back some commissions that might still be owed. So we are working on all those things kind of at the same time and have already begun contacting those parties. If you've gotten one of those letters and you have questions about it, please do feel free to reach out to us. We're happy to discuss that. Let's see, questions specifically about specific defendants and how much they still owe to the estate. That information we will be making that information available in our reports. So we will talk about exactly how much everybody's owed and how much they've paid as part of that. And as I said, we are working on collecting additional assets at this time now to start to cover some of that remaining balances. I know some of you had concerns about some of the homes that some of these defendants are living in while owing large sums of money, and we are working through those issues and looking to collect those assets for the benefit of all the investors and claimants in this case. Clawbacks. What efforts are being made to recover paid taxes on income? We are working with our accountants on that, trying to figure out what makes the most sense and how we can best look to do that. And we are in the process of filing those tax returns for the J&J entities and hope that we will have a good resolution to that going forward. We continue to file those tax returns. As you're aware, those tax returns were not filed for some years, and so we're working on getting some of those filed and trying to figure out ways to maximize the benefit to the estate for that. Next question is, how much is owed by net winners, and are you going after that? Between net winners and commissions, we think it's approximately $58 million that was paid out, and we are looking to go and collect that money back to the estate for the benefit of the losing investors. Next thing, just wanted to remind everybody how you can get in contact with us. And if I have time here, I will open up the chat because I did see some questions coming in there. But the best way to contact us is via email at contact@jjconsulting-receivership.com. Again, that's contact@jjconsulting-receivership.com. Or you can call us at area code 702-832-2299. Again, that's 702-832-2299. And of course, the easiest way to make sure that you're staying up to date on all communications is by going to our website, which is just jjconsulting-receivership.com. Again, that's jjconsulting-receivership.com. And you can go there and you can see all the documents or all the pertinent documents that are filed in the case, as well as any updates. And if you have not already done so, I would encourage you to register on the website to make sure that we have your most recent contact information so you can receive any updates that are going on in the case. At this point, I'm going to go ahead and open up the chat and see if there's any questions in there that I can answer. And we'll go from there. If you have specific questions about a claim that you have, I highly recommend that you reach out to us so we can work with that on a in-person basis. First question from Darius says, will you consider an in-person meeting where we can ask follow-up questions at least once a year? If there is a request for that, I'm happy to host an in-person meeting. to do that. We did host an in-person claims clinic in early September where we allowed people to come in and we assisted them in filling out their claims and accessing their claims data, or if they had questions about their calculations, those things. If we think it makes sense to do one in the spring, then I would be happy to do that, maybe around the time of the distribution, so I can answer questions about that. I would be happy to do that. Question about a creditor board. If you're talking about like a creditor committee like you'd see in bankruptcy, the court is not going to want to do that because of the additional cost associated with doing that. It can be quite expensive. But if you guys have specific questions about something happening in the case, I do recommend you reach out. We are happy to talk with you and discuss things going on in the case. Questions about some of the assets and why people are still living in them. As I said, that will be coming to an end as we do look to collect the rest of the remaining assets now that we are confident in the forensic accounting and how much is exactly owed by every party. Let's see, are the claims matching your estimates? Yeah, so based just on a high level review, over 85% of the claims that were filed agreed with our accounting with no questions. We do believe that there is an additional percentage that could be as high as 5 or more percent in addition to that did agree with our claims, but did not just simply check the box and sign it. They put in information in the claim, which then causes us to have to review and audit it. And so we will do that and take a look at it and see if there's any variances in what we had suggested. But a very, very high percentage of people who filed their claims agreed with our documentation and our information that was provided. Next question is there a whistleblower involved and how much would that person be paid? I'm not sure if there's an official whistleblower. I do know that there was a group that I think most of you saw the article that was run back in March of 2022. I'm not sure if they are considered an actual whistleblower or not. However, any whistleblower that is in this case, if they were to be paid, they get paid out of a different fund that the SEC collects that is specifically just used to pay whistleblowers. So none of the money would come out of anything that we have collected in this case, including any of the settlements. So that information is not, so if there was a whistleblower, will have no effect on payment to investors at all. Next question is there a list of those who profited from the Ponzi scheme and how much each of those owes back? We do not release that information as a whole because because of the fact that these were investors in this case, and we do attempt to protect them. However, if we ultimately have to sue somebody in order to get back net winnings, then obviously that information then becomes public at that time because they will be listed in a court document with the amount that they owe. Assuming people pay back the money without having to litigate against them, then that information will generally remain sealed, although the totals amount recollected will always be available in our reports. So again, we've already begun that process. We've reached out to net winners and asked them to return those funds. If people do not voluntarily return those funds, like I said, then we will seek permission of the court to be able to sue them in order to get those funds back where it makes sense. Do we know the total amount claimed by investors to determine the pool of funds owed? All we can tell you right now is that there's $255 million worth of claims filed. We do think that number will be adjusted slightly, most likely will be downward adjusted as sometimes people claim things that cannot be substantiated or are outside of what the court is allowing in this money in, money out process. So we will continue to refine that number as we move forward. And so I hope that is helpful to you guys. Again, we do think that there will be additional refinements there. Next question is, will there be a second distribution? Yes, there will be a second distribution. There's really not a scenario in which we will only be doing a single first distribution. Usually in these cases, there's 2 to 3 distributions, depending on when the money comes in and is available to be paid out. Next question has to do with Wells Fargo. The question is the settlement proposal substantial? Yes, the settlement proposal is substantial, but I can't give any details on it, because I don't want to risk leaking that information and potentially being subject to sanction, which could cost the investors in the case money. We don't want to do that. What efforts have been made to identify the tithing? We have actually just wrapped up our accounting on that and are working with the parties to try to get that money returned. We don't think that there will be an issue doing that. Just based on some preliminary discussions, but we'll be pursuing that in the coming weeks. So that we hope to have some good news on that in the first quarter. Was there any involvement or agreement from the investors in agreeing to the settlement amount from Wells Fargo? So the answer is no. The investors themselves did not have a say in that yet. And what I mean by that is the investors, of course, were represented in a couple different ways. There's the class counsel, the class is made up of all losing investors in the J&J Consulting case. And so those attorneys that represent the class were responsible for representing the interest of the investors, as well as myself. I was there representing the interest in the investors as well, not from a legal representation perspective, but from a representation perspective in this receivership case. However, once the proposed settlement becomes public, investors will then have an opportunity to let us know what they think about the investment, to let the attorneys know, and to let the court know if they have any concerns about the investment. Whenever we look at settling one of these cases, it's a very difficult decision, first off, because you're trying to come up with a settlement that both parties can agree to and reduce the cost of litigation, as well as reducing the timing it'll take to get paid. I don't know if a lot of people are aware or not, but if we had taken this case to trial, it likely would not have gone to trial till probably 2027. But even if it had been late 2026, you have the trial, which would take weeks, and then inevitably, if we had gotten a judgment or if we had won in that case, then we would have been subject to an appeal, first to the Ninth Circuit and then potentially to the U.S. Supreme Court. And oftentimes those appeals can take 4 to 7 years to occur. And so in any one of those courts could overturn a win. And so that's part of the information we have to take into account when we decide whether or not to accept a deal or accept a settlement as part of the litigation. I'm happy with the results of the mediation, and I think that the investors will be as well, given that what we know about the risk and all the other problems associated with litigation. When will the distribution occur? Again, we hope, as we've said all along, we hope it will be the first quarter of 2026. Again, I think that there's only two things that could potentially slow that down. That is the amount of time it takes to audit claims and then get it in front of the court and have the court make a decision on claims. If there are disputed claims, that could slow down the process slightly. Although we are working with investors, so we hope that there will not be any or very few disputed claims at the end of the process. And then, of course, like I said, with the Wells Fargo settlement, if it looks like it will fund in a time period that we could include it, we might wait 30 or 60 days to get that money included in the distribution. But that is something that we will weigh out. Obviously, we don't want to delay distribution by too long at all, because we want to get the money back into your hands. So if we think it's going to be 60, 90 days, we might just wait or might just do a payout and then do a secondary payout later in the year. Let's see, questions about recovery. Questions about how much we're going to distribute. That'll all be part of the distribution plan when we produce that. We will have to do some holdbacks for potential administrative fees or taxes. So we need to look at that. We do have our tax people working on it and trying to determine if there what any potential tax issues there could be, if any. We don't know that there are any, but we always have to make sure that based on how the things were done before we got involved, that it does not leave any taxes owed to the estate. But our goal would be to get out as much of that money as possible into the hands of investors. Let's see, it says at the beginning of this year, you stated we would get a distribution check by the end of the year. Now you're pushing it out again. The date of the distribution is all based on when the claims were done. And the claims process, as I said, because it was done on December 1st, we now have to go through and meet with people, especially people who filed their claims later in the process, to work through their claims. So I think it'll take us 30 to 60 days to get through that, and then we will submit it to the court. And so we'll get that submitted, and everybody will have an opportunity to see that. Let's see. There's a question about pursuing people that owe money. If we don't pursue it, will they be able to? Yeah, if for some reason we decide that we're not going to pursue an avenue, that would only be because we believe that the cost of doing so would be the benefit that we would get from doing so would be outweighed by the costs. But if that is the case, we could look at releasing the stay of litigation against a specific party potentially. But we're gonna have to wait and see how that plays out, because again, it would only be in situations where we didn't think that there would be a benefit to the estate. Question is, how much was the tithing amount? I don't have that in front of me. I know that it was a few $1,000,000, and we'll be looking to get that back as well. How much was the original lawsuit against Wells Fargo for? The lawsuit itself did not lay out an ultimate dollar amount of how much we had requested. There's argument that we believe Wells Fargo is responsible for a substantial amount of the harm that was done. They, of course, argued that they weren't. And so ultimately, we had to make a decision based on the information that we had there. Let's see. There's a question about how much has been paid to attorneys. That information is all available in our report. How much is paid out to professionals and others in the case is all detailed in there. I don't have that information in front of me right now. A couple of the agents are still living great lives. So we are going after a number of the parties that were winners in this case and that received commissions in this case, and we'll begin collecting on those assets, at any point. Actually, moving forward from here. Are there going to be criminal cases against these people? So, the only criminal case that we're aware of, obviously, is the one against Matt Beasley, which he did recently change his plea in and pled guilty. I don't have any inside information as to whether or not anybody else will be charged. We have provided information, and we do believe that there will be additional charges, but we have no way of knowing against who that will be or when that will be. That is a completely separate agency. That's the Department of Justice is responsible for that. And if you have specific questions about that, I'd highly recommend you reach out to the U.S. Attorney's Office for Nevada. Again, I can't talk about the settlement details, so I'm going to go ahead and skip through that. Would you consider an in-person meeting where we can ask? We already answered that question. Let's see here. Questions about tithing. I can tell you that Mr. Judd did not tithe $30 million. The exact amount, I don't have it in front of me. Like I said, I know it's a few $1,000,000, and we will be seeking to get that money recovered. Will the settlement with Wells Fargo prevent an individual who may currently bank with them from any possible future claims in a future and separate part of this case? That is actually a very good question, because we have seen that occur in the past, and I do not believe, and I will work to ensure that any settlement is narrow only to cover things related to the J&J Consulting case, and would not prevent you from anything in the future regarding any of your other activities with them. Other than that, let's see, questions about recovery. The recovery information is all in the report, so I recommend that. The amount of money from all promoters, I believe the promoter number out of the 58 million is approximately 8 million of the 58 million, and so that would be, and again, that's an approximate, and then about $50 million in net winnings. So that is what we're going to look to be getting back from those parties. That looks like all the questions that have come up in that chat. Again, if you have specific questions about your claim or about the case, would like to talk about those different pieces, we're happy to talk with you individually. The only thing is, of course, we cannot talk about the Wells Fargo, any of the details of the Wells Fargo litigation yet. Although I do hope that in the next couple of weeks that we will see that filed, and then that will become public information, and we can discuss it further at that time. And in fact, if investors want to have a discussion about Wells Fargo once the Wells Fargo documents have been filed, we would be happy to be able to do that. To have that conversation, maybe schedule a call in the interim so people could ask specific questions about it. But ultimately, that when that gets filed, it's up to the attorneys. They are working on the language of the agreement, and that's what has to get worked out is that ultimate language to make sure that everybody's happy with it. But thank you guys for taking the time to get on this call. I'm excited that we're very, very close to being able to get money into the hands of investors. We've been trying to do that, and I'm very, very happy with this claims process. Like I said, the number of claimants that have filed, we think is 97% of what we expected to file. And the dollar amount is in excess of the total dollar amount we believe is owed to investors, which we expected because we know that sometimes people make claims for stuff that they're not necessarily entitled to under the process. So we're very, like I said, we're very happy. Everything has come together exactly as we thought it would. This claims process took a long time, but ultimately led to the result of this claims process going very smoothly. And we anticipate it to continue to go smoothly through the filing of the omnibus objections for the claims and the distribution process. So thank you guys again for your patience. I know that took a while, but again, given what we started with and what we were able to work with, I'm very, very thankful for my team and everybody else who supported this process and to the investors for giving us the time to do it right and make sure that the information was right. So thank you again, and we look forward to giving you an update here in the future.